Evans, who's immediately to my left, who is the Chief Planning Officer for the Council. And then to his left is Mr. David Hughes, who is the Head of Planning Policy.
Mr. Asram as well, or not today?
No, Mr. Asram is not likely to participate orally, but he'll be assisting us.
Okay, thank you.
Morning, Ma'am. Howell James for Nexus Planning, representing Taylor Wimpey.
Good morning, Leanne Buckley-Thompson at number 5 Chambers, representing Barwood Land.
Good morning, ma'am. Michael Schwartz, Old Lyonian.
Good morning, Ma'am. Alex Yearsley of Bell Cornwall, representing Old Millie Hillians Club.
Morning, Ma'am. Mark Barrett from the Home Builders Federation.
Morning, Ma'am. James Callaway, representing Solent.
Morning, Ma'am. Nicola Forster, representing from Savills, representing Whitbread PLC.
Thank you very much. Could I just ask as well that when everybody departs, could you just use the bin, put your rubbish in the bin, because we had quite a tidy up yesterday when everybody left, or poor Louise did. Can I just check, so usual procedure for the council, somebody should be making a running note of any main modifications as necessary on a separate schedule. In addition to that, we've got another schedule running, which is action points for the council. And at the end of today, we will go through any actions that we've covered in terms of these policies that we're going to look at today. So somebody's doing those, are they? Yeah.
They are.
Yeah. Okay. And was there anything else arising from yesterday that you need to cover?
No, Mum, there's nothing at this time.
Okay, so I think two parties have requested that if we can, and apologies to everybody else, to just slightly jiggle around the agenda, and if we cover 10.5 in the first instance, which is policy H09, and then you can then depart as you see, as you would like to, and then it's my intention to then continue the agenda as set out to get to hopefully policy H06 before the lunch break. So that's where I'm intending to plough through to, and then the remainder this afternoon, if that makes sense. So H09 is large-scale purpose-built and conversions for shared living, and this is page 151 of the plan. And I raise a couple of points in the MIQs in terms of whether Part AC is flexible enough in terms of whether it should also include Harrow's designated town centres and areas with a high PTAL rating, and then secondly, what evidence the council to have to support parts B and D. That's a little B and D of the policy. So if you can just, in the first instance, talk me through, do you have such a policy in the adopted plan? Or is this something new that you're looking to address?
Ma'am, this is something new that we're looking to address in this new plan.
So how have you approached the overall development of the policy wording then? Just give me a bit of background.
Okay, ma'am. So in terms of drafting the policy response to large-scale purpose-built shared living, and also in terms of responding to the overall policy response in the plan draft policy actually reflecting that, we've been informed by evidence in relation to the extent of need that has been identified in terms of co-living. I call it co-living for shorthand. So essentially our evidence base, so it's a local housing needs assessment, so that's EDH02, essentially identifies that there is no strong need for co-living sort of developments. So this is very much sort of the starting position in terms of the relative need for this type of product versus the relative need for other types of housing as such, for which we do have clearly identified a much stronger need for that.
Okay.
We do, however, obviously recognise that there is potentially a role that this type of product would play in terms of the housing mix within the borough. So we've essentially set out a policy that seeks to facilitate the sort of co-living type accommodation within the borough, but then also recognising that there's not a significant need for that type of housing as such. So therefore, the policy itself really just sort of identifies the preferred locations for the for such type of housing, and then also sets out how we sort of make sure that that sort of provides a meaningful contribution to sort of the housing mix within the borough. And then obviously further on, in terms of the policy, there's the design aspects as well. So it's really just responding to the fact that there is the level of need that's required, or limited level of need that's required, and then just identifying where, if we do facilitate this type of development, where that should occur. And that is obviously also in the context of policy H16 of the London Plan, which includes the sort of mass of detailed guidance or policies in relation to large-scale purpose-built shared accommodation as well. So it's obviously been informed by that.
Will you just let me pull that up? It's H16. So H16, this is the London Plan, H16 A little 3 talks about the located in a well-connected area for local services and employment, which I think is why the question was prompted. So why is the council not following that approach?
Sorry, Mayor, my London Plan's is coming up now.
Oh, I do apologise.
Yep.
It's, well, I think you can click through on the hyperlinks, can't you? It's page 81, I think. No, 211.
So in terms of London Plan Policy H16, Part A3, so it indicates that such development should be in an area located within an area well connected to local services and employment by walking, cycling, public transport, and doesn't contribute to car dependency. In terms of the opportunity area, that is the most sustainable location within the borough. It has the most local services within the borough, and it also has a significant element of employment within the borough. So in terms of the requirement of policy HO9 C, in terms of focusing this type of development in Harrow and Wealdstone opportunity area, we do consider that it meets that requirement.
Right, okay. Is that approach reflected in your other policies there in relation to, for example, older persons accommodation or students accommodation? I think you've taken a broader approach, haven't you, in terms of town centres and VTEL ratings, but not for this type of housing.
Yeah, that is correct. So for other types of housing, we have taken a broader approach.
Yeah.
But that's because there's a much greater need for that type of housing as such. So in terms of the limited need for this type of housing, and the fact that the opportunity area is going to see a highest sort of level of development within the borough, given that there's a limited need for this type of development, and given that also it can contribute to mixed and balanced communities, the emphasis was to really focus on the opportunity area to ensure that any large-scale purpose accommodation that does come forward makes that contribution to mixed and balanced communities in the area where we're anticipating the most growth in terms of housing within the borough.
Right, and then you go on to say at 10.5.3, if we had more flexibility, you consider that this may adversely impact the delivery of self-contained housing.
Yes, so ma'am, there's two elements to that. In terms of areas outside the opportunity area, there's a lesser level of development opportunities within our town centres and district centres, for example, compared to the opportunity area. So in terms of making sure that we are meeting the greatest need or providing housing where there's the greatest need, which is your self-contained C3 accommodation, we are sort of essentially saying that where those opportunities exist outside the opportunity area, but within our district centres, that that should be the C3. So for the limited sites that we have in some of our district centres, that the priority in terms of evidential need is for C3, and that's why the policy just limits this type of housing to the opportunity area.
Okay, and then on to part D. That's actually 10.6. The evidence to support the approach adopted within parts B and D. If we just look at part D first. So this is this 250, no two schemes within 250 metres of walking distance of each other. And that, I'm just a bit confused by the, is that the correct policy reference you've given at on page 10, number 3? You say in line with London Plan Policy H09. Is that the correct reference, or can you see where I'm looking? Yeah.
Yeah, ma'am. So in terms of that policy, the particular element of that we're referring to is is part C. And so, sorry. What's that? No, sorry, ma'am, that is an incorrect reference. In the context of that paragraph,
Yeah.
it is very much about the mixed and balanced communities that the London plan seeks to provide.
Yeah, but what policy are you referring me to then? H9, should it be H9?
No.
No. So is there a policy, I'm specifically talking about this 250 metre walking distance in terms of avoiding over concentration, because I can't see anything in terms of the London plan on that. And then the other reference that you've done through the hyperlink at the bottom, to the large-scale purpose-built living London plan guidance, that just talks about if you have an emerging concentration, then councils with appropriate evidence might need to look at developing policies. So I don't think you've identified anywhere where spatial or delivery concentrations may be emerging, have you?
In terms of the
Sorry, Mr. Hughes, can you just answer, because we've got a lot to get through today. Has the council identified any evidence in terms of emerging concentrations of existing patterns of this type of use?
Yeah, in terms of schemes that have been permitted, for example, there are already 4 within the opportunity area.
Yeah.
And we also then do have sort of active interest in terms of schemes within the opportunity area as well.
Yeah.
So that collectively suggests that there is an emerging risk for overconcentration based on that sort of a level of schemes that are coming forward.
But that's what your policy objective is, isn't it? To concentrate those uses. That's what you just explained to me, that this is where they're going to be for the reasons that you've set out.
It's for the reasons which we've set out.
Yeah.
But there's also a need to make sure that that still doesn't translate into a concentration. So we believe that the opportunity area is still the most appropriate location. But in managing and focusing this type of development in the opportunity area, we also then do need to sort of recognise that that could risk over-concentration. So the policy response to that is to include that 250 metre test. So it's essentially striking that balance between mixed and balanced communities, the level of development within the opportunity area, and also making sure that that still then doesn't result in any sort of adverse impacts.
If I could just jump in for a moment, I think this over-concentration point comes in the Mayor's guidance document.
Yes,
on
that's what I'm
large-scale
looking at.
building. That's where it comes from. And I can give you the reference. I'll have a look for it and give
Well,
it to you.
I'm reading what it says
got
there.
it.
That's what I'm quoting to Mr. Hughes. So it's very specific, saying ideally local plans should identify where spatial or delivery concentrations may be emerging and impacting on the ability to ensure mixed and inclusive neighbourhoods. I'm questioning what evidence the council have presented in terms of your local plan that demonstrates that that is happening. So you may well say that, well, there's 4 now and we've got other pre-apps in and we think there might be a problem. That's not the same as saying there is an existing problem.
Isn't the point to avoid the problem occurring?
Yeah, so,
I mean, that's the point of
so in terms of the London plan guidance,
Yeah.
so essentially at paragraph 2.2.3 of that guidance, it basically indicates the impact that may occur in terms of neighbourhood housing mix.
Yeah.
The negativity, it may be more negative where there is an emerging concentration of this or similar accommodation relative to conventional housing.
Yeah.
So in this case here, we consider that there is an emerging concentration, and there's a risk of that, essentially. So
Yeah, that's not the same thing. Sorry, but that's not the same thing. If you carry on what you're reading, then go on to read 2.2.4.
well,
It
it's
says if you've got evidence to that effect, then the council may wish to consider developing policies to ensure the mixed and balanced communities. And I'm asking what evidence the council has produced on that. You're talking about 4 schemes today.
Like I say, that is very much just based on what's been permitted and also the existing pre-apps. So for us, that represents the emerging risk and therefore the opportunity to have a policy response to that.
So 4 consented schemes, did you say?
Yes.
4 consented schemes. And 2 at pre-app, is that what you said?
Yes, at least 2 at pre-app. And those 2, ma'am, are actually within close proximity to 2 of the consented schemes. In fact, those 2 schemes have been built out, those 2 consented schemes.
Okay, I'll have a think about that particular part of the policy. Then at 4.9.10 of the supporting text, it talks about a reference to a legal agreement. Just checking whether that wording is effective where it is.
Thanks, Ma'am. Just for clarity, are you questioning whether it may be better placed within the policy itself rather than in the text? Yeah. Take your point.
Yeah. So the council look at that, will they?
Yeah.
And then parts E and I, whether they repeat other policies within the plan. I think this is a general theme in terms of a number of the housing policies. There's a lot of repetition. So I would suggest that E 1 to 3 is deleted. And sorry, on G, should that be, it should provide flexible workspaces, should that be or are you expecting these schemes to provide both?
Both, Ma'am.
Both, okay. Okay, does anybody have any questions to raise in terms of H09? Now would be the time if you want to raise anything. I think you wanted this policy dealing with first, is that right?
Well, I think in terms of the location and priorities proposed, we agree that we think it's very restricted to direct living accommodation just to the opportunity area. We agree that the opportunity area is appropriate, but we think it's limited in its approach and inconsistent with the London Plan and governing guidance and the Code of Living supplementary planning guidance, which specifically directs co-living to areas which are highly accessible in terms of hotel zones 4, 5 and 6, and effectively where there are lots of facilities and within town centres. So limiting the co-living shared accommodation to one location would be detrimental to the council's housing delivery and also the affordable housing delivery, which is obviously significantly.
Does the council not see any tension between saying that it has to be within the opportunity area, but then did the over-concentration point? You don't see any tension there?
Thank you, Ma'am. I would say that I don't read it as so clearly defined as that. When we use the word, I think I'm looking at Part A, small c, proposals should be located within the boundary of the opportunity area. It's
Yeah.
not a must or can only be. They should be because of the sustainable location which the opportunity area represents. That doesn't rule out applications coming in which are either over the border of the opportunity area or in another part of the borough, but there's a preference or priority for them to be within the opportunity area. I think we'd use a different word than should if we intended it to be exclusively within the opportunity area. So individual applications will still be considered on their merits.
Well, 4.9.8 goes on to say this means that LSPBSL schemes are unlikely to be suitable or viable in locations outside of the opportunity area.
Acknowledged.
Yeah.
But I don't think it contradicts what I said.
Okay, would the council like to respond any further on the points that Ms Foster has raised?
Yeah, I think just picking up the point that you raised a minute ago in the light of the tension, the potential tension. I don't think there is a tension because of the explanation given earlier in relation to the need for this type of housing and the council not considering it to be a priority and being concerned that it's going to crowd out the actual need that's required and the limited space in the district centres and areas. So when you put all of that into the balance, then and see it within that lens, then there isn't a tension because we don't want this type of housing everywhere for the reasons explained. There's still a risk of over-concentration, and that's still a real concern for the council. But if there's a flexibility here, acknowledging that this housing can play a role, but then it needs to be in this particular area so as not to prejudice the delivery elsewhere. So I think it's all these moving parts lead to a logical strategy.
Hello.
As a local resident, many of us, and I speak for the group that's campaigning against this development, many of us think overconcentration has already happened. and for that reason, this development is inappropriate.
I think just on that point, just to sort of pick that up as well, the guidance, the Mayor's guidance that we looked at, that does also acknowledge that this type of housing or this type of development has positive and negative impacts.
Yeah.
So, and that's, I think, that very point that there are emerging concentrations, or there's a genuine concern that can arise in relation to this type of housing. And again, that all goes into the mix. And ties in with the strategy. It's a defensible strategy for those reasons.
Yeah.
Sorry, I'd just like to go back to the point of tension. I think there is tension between the policies, the emerging policy with, on one hand, you're looking to restrict shared co-living accommodation within the opportunity area, but also to encourage and at the same time you're looking to restrict over-concentration in that one area. So surely, whilst you're encouraging it, you're also restricting it because you're only allowing it within one area on a very limited basis. So I think those two policies are contradictory in themselves. If you're only allowing it in one area on a certain term, that will affect the degree of shared accommodation. And as I said, given that for housing, social housing, which now forms a big part of shared living, it's an important factor to consider in the overall housing delivery. I think that's within the consideration. It also contradicts the recent change to the PPF under paragraph 61, which talks about boosting housing delivery, and shared housing is considered to be an important format, providing alternative forms of housing for different markets.
Sorry, I think so could you
Point I would
yeah,
like
sorry,
to
but
add.
I need to be able to see your nameplate. If you
Oh,
could just
sorry,
turn it
sorry,
sideways.
Kazi.
Okay, thank you.
The other point I would like to add is that we feel, again, the infrastructure in terms of schools, roads, GP services, there has been insufficient provision when you take the impact of this development in.
Okay, we're not talking about the specifics of a scheme here. We're just talking about the general policy that the council are proposing in terms of these types of development going forward.
But
So we're not.
we
This
feel
isn't.
that those should be in that policy, and we don't feel they are. Consideration is not being sufficiently, I don't know what the word is, but the
Okay.
policy doesn't reflect that.
Okay. The council like to say any additional points on this policy, because we are going to move off policy H09. Yeah.
I'd just like to flag that subpoint F further restricts co-living within the opportunity area, because you can't be brought forward on sites that are allocated C3. So Solent's position is that if there's a need demonstrated, it shouldn't be restricted.
So unless adequate evidence is submitted to demonstrate viability issues, you don't. So just repeat what you said.
Solent's position is if there's a need, I don't think it should necessarily be viability issues. I think if there's a need demonstrated and the site can meet the remaining supplements, it shouldn't be sterilised.
So any additional points on H09, and then I'm going to ask council just to respond on all of those points.
Mum, I'll just pick up a few points, and then if Mr. Hughes has anything to add, he will. Mum, I think it just goes back to the point, really, that has been made before. There are many ways to skin a cat. I mean, the soundness tests require a justifiable and effective policy. Here, the council has taken into account all the various factors it's explained to you, and you're aware, of course, of the other issues relating to the need for family housing, the need for particular mixes that we're going to come to, and affordable housing. And bearing all that in mind, this type of housing is not a priority, and there is a risk of it prejudicing other delivery. Taking that into account, it's aimed to be flexible, but yes, it doesn't encourage a free-for-all of this type of development across the district. It doesn't do that. That's a strategy based on the evidence that the council has, that it's arrived at in relation to the strategy. So yes, it does have those restrictions, but those are deliberate, taking into account the other planning considerations.
Okay.
Sorry, can I just make one more point?
Yep.
I think there's no guarantee that the sites at Priya are going to come forward, so I think it's not strong.
Okay. Sorry. The way we need to do it is we will ask the council to introduce the policy, then we have the discussion, and then the council will have the final say. So this will be the last point on this policy.
Just very quickly, just going back to the evidence base. So in the housing needs evidence base, it is identified that the view on shared living is based on the growth of single-person households, but that is not necessarily co-living, and it's recognised in the conclusions, but it says it is difficult to project the need for studio apartments or co-housing schemes. So I question the validity of the housing need for co-living, or whether that's been undertaken sufficiently to inform policy.
Do you want to say anything, David, at this moment? Go on then.
Thanks, ma'am. So taking a few points in turn. So in terms of the comments made about location and potential conflict with the London Plan and the Mayor's London Plan guidance, we don't see that there is a conflict with just restricting it, focusing this type of development on the opportunity area. So whilst paragraph 2.1.1, the London Plan guidance, sets out essentially where the Mayor thinks, or where the Mayor says the types of locations that are considered to be well connected and well served areas, that shouldn't be construed to say that that is where all these schemes should be allowed to occur. And that's reflected in the second paragraph there, so 2.1.2, which basically says these locations may be refined further by local plans according to their wider spatial and housing strategies. And that is where, in terms of where development can occur in the borough, and also the housing need, the overall sort of housing need requirements, that's really what's refined and driven our sort of approach in terms of the opportunity area. So I wouldn't accept that there is a conflict that's been suggested. In terms of the affordable housing provision, it's certainly acknowledged that the affordable housing policies do apply to this type of development, but that will, because of the very nature of this type of development, will mean that that will be in the form of a monetary contribution, or if it's a mixed-use scheme, it will be provided elsewhere on the site. But essentially, whilst the affordable housing policies apply here, they will also apply to the C3 type of housing. And if we, if each site comes forward and provides the C3 affordable housing on site, then that again more strongly meets the need in terms of affordable housing and the hierarchy of providing affordable housing on site. So I don't think there's necessarily can be a distinction between, this doesn't favour affordable housing provision as opposed to sort of C3. Again, in terms of the evidence-based side of things, I think at paragraph 5.4.4 of the housing needs assessment, so DBHO2, again, it sort of acknowledges that there is a role for this type of housing, but then based on the actual sort of household formation rates for the age cohort that would typically be in this location, or this type of development, sorry, there just isn't that strong need for it. So again, it identifies a role, but not an overriding or comparatively strong need. And again, the policy really reflects that. Yes, there is a role for this, but we just need to make sure that it doesn't, any provision needs to still have regard to the limited need compared to other housing types, including particularly family-size housing, which obviously this is quite the opposite too.
Okay, could Part F be reworded to be slightly more positive? So removing the will not be supported and coming up with some appropriate alternative wording.
Yes,
Yeah.
we can do that.
Okay, so that concludes the discussion on H09. So we're now back to the agenda as it was in terms of, so it's affordable housing now, policy H04, which is 9.1 to 9.7. Can we just pick up Mr. Berendt's point from last week, which I think you probably recall, and it's in his matters statement about the reference between the 35% and the 50% target at Part B. Do you recall that discussion we had week before last? Yeah. Does the council have a view on that? Help if Mr. Berendt just summarises. Yeah, I think, yeah.
Yeah, thank you, Mark. It's really interplay between, I think, the policy in terms of the spatial strategy, which says that an overall objective of 50% across the borough.
Yeah.
And then this is then reflected in H04 in terms of the genuine affordable housing policy, which states that there is a requirement in terms of the borough-wide target of 50% affordable housing will need to be explored in order to achieve this policy. So we have the 35% of all gross residential, which is consistent with the London plan in terms of the fast track. But then it moves on, Ma'am, to say that to apply for the fast track route, as well as demonstrate all options have been explored to achieve the borough-wide target of 50% affordable housing. I don't believe that's consistent with the London plan, in terms of which it's basically the fast track policy says that if you're delivering 35%, you're delivering 35% and you move through towards consideration, almost a no questions asked type of policy. It's only where you're looking at challenging that in terms of viability, or the other specific elements that are mentioned within H5 of the London plan in terms of different types of policy, which I think are reflected within this policy in terms of the 50%. So I just believe there's a confusion there in terms of what this policy is seeking to achieve in terms of the 35%, but then saying, actually, but you need to explore 50% as well, which I don't believe is consistent with the London plan in that respect. And I think could lead to confusion amongst decision makers as to what, and applicants as to what they're seeking to achieve and should be required to deliver. And I think this is partly, I think it was in, which I couldn't find at the time in terms of that, and Mr Hughes helpfully pointed me to the direction in terms of 9.1.5 of the statement, which says the requirement for 50% of all new dwellings. So it's that confusion in my mind in terms of what the council was suggesting in their statement, what was in the policy itself, and then what the London plan says in terms of a 50% overarching goal. But actually, that's not the requirement in terms of development management policy, because you'd expect some schemes to come forward 100% affordable housing. So you would balance that out in terms of what can then be delivered on site. So I think that was my main concern. I suppose the key point is that the removal, as well as demonstrate all options have been explored, would be a starting point, Ma'am,
so
especially in terms of viability as well.
Sorry, proposals must ensure an initial minimum, so it was the wording an initial minimum, and then as well as demonstrating all options through to affordable housing.
Yes, ma'am. I think it's just the
it's those parts of the wording. I'm assuming the council doesn't have any issue with that.
Ma'am, I think in terms of policy HO4 Part B, so essentially it's a sequence in terms of you must meet the initial minimum 35% to comply or to meet the fast track route. So that's the first thing which you have to do. So if you make the 35%, then you're eligible for the fast track route, so you have to go through viability assessment. However, any scheme in that instance is still required is essentially still required to see if there's opportunities to boost delivery beyond that 35% through use of grant. And that's consistent with policy, London Plan Policy H4 Part A2. So again, that's essentially saying that, well, perhaps if we take it sequentially according to H4, so 35% trigger is Part A1 of H4 of the London Plan, and then Part 2 of the London Plan says that you should also then use grant to increase affordable housing delivery beyond that level which would otherwise be provided, which would also include the 35% that you must achieve to meet the fast track route. So it's not saying that you have to do 35% and do the grant in order to qualify for the fast track route. It's basically, even if you met the 35% and meet the requirements of fast track route, you are still required to demonstrate if grant has been explored to push it beyond that.
That's not quite how I read that policy. That's not your wording doesn't refer to the use of a grant either.
But that would be one option in terms of using grant to deliver beyond the 35%.
Mr. Barents, do you want to?
I wouldn't agree with that position in terms of the London Plan. I think the London Plan provides an overarching strategic target of 50%, sets out in Part A1 that it should meet the threshold target, and that is the minimum consideration that should be taken forward. And if you hit that minimum threshold, then it is a no questions asked principle. I think there may well be opportunities where local authorities and London Plan want to look at how they may well use grant to go beyond that, but that's not a consideration for the applicant to make. The applicant is required to ensure that they deliver as a minimum that 35%. the fast track means that if that 35% is delivered, then that should be considered as consistent with the London plan and the local plan, and therefore can move forward without further consideration as to that. Otherwise, there's no point in having a fast track scheme. Then would be my argument, Ma'am.
Did you not see that point?
Thank you, Mark. Just a few words from me. I don't disagree with what Mr. Berend is saying regarding the Mayor of London's policy position in the London plan. I think what we are seeking to do here in our local plan is to add to that in respect of the current demand for social, genuine affordable housing, social rent within our borough. So I suppose this is an additional requirement in my mind that we're seeking to adopt through our local plan. We are not disagreeing that the fast track route exists through the London plan, but we are conscious that there are currently huge attempts being made to increase beyond 35% social rent within our borough. We would like applicants to explore all possibilities to go further. I don't think I can add anything further to that. Either it's acceptable or it's not, I think, for us. It's important for our borough that we seek to achieve that.
I'm just going to check what if the statement of common ground with the JLA said anything about it.
We've had a quick look. We can't see anything in the statement of common ground, which
I think it's in their representation, actually, their Reg 19. That's representation 201. On page, it's not page numbered, I'm afraid, but it's probably the third page down on that Regulation 19 representation. So it refers to the fact that you've got the strategic target of 50%, which reflects policy H4, which is noted and welcomed. Then it talks about 10-year split, and then it talks about you following the Mayor's threshold approach to affordable housing. Makes it clear that schemes which are following the fast track route, schemes will be able to follow the fast track route, which is consistent with LP 2021. Can you see that? Can you read the last paragraph on there as well? Yeah.
we've read it, Mum, and I can't see any reason to change the position we've adopted in our local plan, which is before you. And we didn't do so in the light of that. And the statement of common ground was subsequently agreed.
But that makes the distinction between the 35% and the 50% in the last paragraph, yeah? So doesn't that accord with the view of how others are reading the London plan?
Sorry, I didn't disagree with the way in which the London plan is being read.
Right,
no,
okay.
No, I started off by saying I don't disagree with the way
Okay.
the London plan is being read. Yeah.
Okay, I'll come back to you then on that point. Okay. Could I just check the first reference when you say targets on A? Unless exceptional circumstances can be demonstrated, refer to E below. Is that correct, that reference, or should that be... I'm not quite sure that's the right cross-reference. Should that be to K? Because E talks about increasing the amount to be secured through grant funding.
Might it be M?
M.
Yeah, to promote inclusive and mixed
Yes,
communities,
yeah.
all new affordable housing should be delivered on site. Off-site provision or payment in lieu.
Yes, correct, yeah. So E that should be M. Right, and then I'm going to come back to you on B, and then part C then talks about the maximum levels. Just clarify me this reference at D to policy H5 of the London plan. Development proposals will carry greater planning benefit. Which part of policy H5 are you referring to there? I'm not quite sure what that part of the policy actually does or what it means. So because you seem to be sort of making an assessment on planning judgment within the policy wording. Which isn't probably an appropriate place to do that, I would suggest.
Ma'am, the reference to policy H5
Yeah.
in that context under D,
Yeah.
I think it's referring to H5C, where it talks about to follow the fast track route.
Yeah.
It should meet all the following criteria, and then as well as looking at the threshold level, the tenure split, in part 4 of that, it says demonstrate they have taken account of the strategic 50% target and have sought grant to increase the level of affordable housing. So I think it's going beyond it's looking to go to the maximum viable amount of genuinely affordable housing in Part D of our policy, meeting the minimum level of affordable housing without public subsidy. So it's looking to go with public subsidy, and then I think it's page 5, Part C, brackets 4. I think that's where we are.
Right, sorry, it's more the first sentence, development proposals will carry greater planning benefit.
Yes.
So what you've said is a given, isn't it, that that's what a scheme would need to do?
Yeah.
But I don't think the policy wording can then venture into making an assessment on planning judgment based on you're preempting. I mean, you could be looking at a scheme, for example, where there's all sorts of other issues, and you're preempting the weight that would be attached to this within the policy.
Yeah, I think I'm tending to read H5, and the London plan is seeking to go in that same direction, which is you meet the minimum threshold, but they're also being asked to demonstrate they have taken account of going for the higher thresholds by using grant.
Yeah, but Part C is specific to the fast track route, isn't it?
Yes.
That's not the wording that's then mirrored here. I'm not sure what it's really adding, is what I'm saying, I suppose. Yeah. Yeah, because E covers a lot of what you've just said, and in any event. And I had a specific... So we've discussed consistency with the London Plan H4 at 9.2. Does anybody have any comments to make in general terms about the council's approach to affordable housing in terms of the quantum of delivery? Now would be a time to raise that. Mr. James.
Thank you, Ma'am. Affordable housing is always a very important subject during local plan examinations, and somewhere like Harrow, where the affordability ratio is 14.93, I think is a really key topic. So I don't think we should take this lightly in terms of the council's position. So within the policy, the council indicate a target of 50%, which is consistent with the London plan as we've just gone through. If we turn to the evidence in relation to affordable housing, which is document EBH02,
yeah.
The council's provided one of the figures as well within its examination statement helpfully, but I think the starting point probably for me, Mum, is figure 54.
Do you have a page reference?
Yeah, sure, I've got it written down. It is page 75.
Thank you. I'll just find that.
That's all right, no problem. This is right at the bottom of the page.
Yeah.
So this figure sets out the comprehensive position of the council's evidence with respect to the housing need within the London Borough of Harrow based on just meeting the London Plan housing target. So it doesn't reflect the actual need, it reflects the needs based on meeting that target. And you'll see within the columns there's the sort of two from right column, sorry if that makes sense, is the total affordable housing need within the London Borough of Harrow, which is 7,870 dwellings, based on, again, that total target of 16,040. So that equates to, by my maths, just over 49%. So actually it is just below the 50% target set out within the policy. Now, just for reference, Mum, figure 48 of EBH02, which is on page 64 of the document, sets out the actual affordable housing need for the London Borough of Harrow.
Yeah.
which is 16,010 dwellings, and that's just affordable housing. Now, I do appreciate there are references within the documents of PPG and the way that that affordable housing need should be based upon a housing requirement, so shouldn't be taken as a sort of face value figure, but it is clear that the affordable housing need within Harrow is much, much higher than the figure within figure 54. Sorry, yeah, the 7,870 dwellings. So that's just a bit of context. But in terms of the 7,870 figure, and in terms of how that would be met through the plan, now we understand the 50% target across the borough would achieve that figure. However, as Mr Burhard has mentioned this morning, the 35% fast track approach to the London plan is in place. If sites were to come forward through that route and demonstrate delivery of 35% affordable housing, they could proceed to secure planning permissions in accordance with the London plan and potentially subject to the revised or revisions to policy HO4 of the Harrow plan, they could achieve permission. So that would enable developments to come forward, essentially delivering 35% affordable housing, which, if all schemes were to come forward at that rate, would clearly achieve a lot less than 7,870 dwellings. So the figure within figure 54 of EPHO2. So to address that, a number of schemes would need to come forward in excess of 50% in order to rectify that, if the council are only to meet the housing target, which is the approach set up with the plan. And I've made comments previously about the spatial strategy, Mum, and the way that works. I won't go into that. Having looked at the site's allocation requirements this morning, I couldn't see any specific requirements for sites to achieve more than 50% affordable housing. So on that basis, I cannot see how the plan is deliverable in terms of meeting its affordable housing needs and achieving consistency with paragraph 63 of the MPPF, and that being the 2023 version.
Thompson.
Thank you very much. I'm not going to go over ground that has just been raised. It's just to flag again a point that came up in the context, I think, of matter 3 and question 4.7 in terms of viability.
Yeah.
And it was the point in relation to how the target of 35% had been assessed. Now, my note and that of my client was that Mr Lee had suggested that the council had assessed mid-value areas, and then when asked whether or not low-value areas had been assessed, my note seems to suggest that they hadn't. My client's just seeking some clarification from the council really in terms of that. It's linked really to the submissions you've just heard in terms of concern about the extent to which the affordable housing need would be delivered. Because of course, if there's an issue in terms of what the council has assessed in terms of the 35% alone, that raises a further concern. So I wonder if they might be able to assist us on that.
Anybody, any additional questions on quantum of affordable housing? No. Okay. Do the council want to respond on those points then?
Ma'am, so in terms of the 35%, and obviously then how do we get to the 50% overall strategic target? I mean, in terms of SP3, it makes it quite clear that the 50% target will be achieved from all sources of housing delivery. So it's not just necessarily sites that are delivered through the planning system, and it's not necessarily sites that are delivered just through policy H4. But it would also be affordable housing that may be delivered through additional grant funding, for example, and also delivered through specific interventions by landowners to provide 100% affordable housing. So we have some recent examples in terms of that, in terms of the council-led schemes that have been delivered at 100% affordable housing. We also have another scheme that was delivered in the past couple of years that again was 100% affordable housing, so that was an origin scheme in Wildstone. So there are examples where we have delivered more than what the the policy would require, because again, that's been funded through grant, through council's own application of funding to achieve, figures and delivery above that 35% and also above the 50%. And that therefore means that, there are examples where we have, practical examples of 100% schemes coming forward.
And are there no site allocations where you're seeking to secure an uplift in the affordable housing, as in a specific criteria within the allocation? I'm thinking of some of the council-owned sites that you've put forward. I mean, we'll look at it in further detail when we start looking at the site allocations, but Ms Buckley-Thompson has made the point that there aren't any allocations where you're looking to secure that in any event in terms of the criteria. Is that correct?
I think it's correct, Ma'am, in the sense that it's not specified in the allocation in the plan.
Yeah.
But in practical terms, the council's own site, which is coming forward, I think we alluded to it yesterday, the Poets site, which is just under 1,100 homes. We're in the final stages of negotiating grant to take the affordable housing allocations there from 12 to 43% via grant, by the grant route, and the GLA is supporting that in the current discussions, which will be going to committee on the 14th of October. So that is a council scheme, and that's a live example of where we are seeking to go beyond 35% with the support of the Mayor's affordable housing grant programme.
Yeah, any at 50%?
Active, no. Historically, we have secured permissions way beyond 50%, over and above the ones that Mr Hughes has referred to.
Could you reflect on whether any of the sites that we're going to look at in terms of the site allocation sessions should be looking to have that as a development criteria?
By all means.
Yeah.
Okay. Thank you.
And did you respond on all Mr James's points there? Well, there's a specific point about the viability testing as well, wasn't there?
Ma'am, so in terms of the evidence base and the viability assessment, it did test the full range of affordable housing percentages up to the strategic target of 50%, and it did assess a full range of value levels across the borough. So there's just bear with me, essentially on figure 2.16.1 of that document. So it's EV.
Sorry, 2.6.1.
2.16.1. So
6.1.
So that essentially demonstrates the levels that were tested.
And then in terms of the value areas?
Yeah, that is the value areas. So that basically demonstrates the different value levels across the borough. And then the table series from page 35 of that then goes through and tests a whole basically presents the results of the viability testing at those value levels, and also the full percentage range as well, from 0% affordable housing all the way up to the 50%.
Okay, thank you for those. Is there anything else you want to add?
No, I think that sort of answers that question in terms of, yes, that it did test the full range of values and the full range of percentages.
Yep, Mr. James.
Thanks, I'm sorry, I'll be quick. That's useful, but I don't think we've seen complete confirmation that 7,870 dwelling figure can be achieved by this plan, and the plan would be effective based on what we've just heard. I think, just to emphasise, it is a minimum figure. It is restricted based on the council only looking to meet the housing target. So I think it is a very critical point. I know we've heard some examples, but we don't have any firm evidence before this examination at the moment that that is deliverable and effective.
Okay, I'm going to have a short-term pause now. So we've just to summarise where we're at, we're still on policy H04, and I believe that we have covered 9.1 and 9.2. So we will, when we come back, we'll start looking at the 10-year mix and the remainder of the policy from Part G onwards. So we'll have a 15-minute break. So we'll be back at 11:35. So the hearing's adjourned. Thank you. To 4. I'd raised some questions regarding the 10-year mix, which you've responded to at 9.3. I don't have any additional comments to raise about that unless anybody else does. And similarly, the question regarding prioritising the delivery of social rented housing, and the council have responded at that at 9.4. So I don't have any further questions on that. And then Part HD, where you talk about meaningful discussions with registered providers. And I questioned whether that was clear to a decision maker how to respond, and I think you were quite positive there in terms of I've made a note that you were positive about amending the text. I'm rereading your text, and maybe you weren't. I acknowledge that there's arguably more of a process requirement that the council will be open to modification. So could you do that, please, as set out at 9.5.2. And then similarly, I think you had agreed on the issue of Part N and vacant building credit, that perhaps wasn't necessary. So that's also to be deleted. Is that right? Are you content with that?
Oh, yes, ma'am.
Yeah. Okay. Right, any other questions on H04 then? Otherwise, yes. Mr.
Thank you, ma'am. Apologies, I think I might be veering back to part B of the policy. I've just, if you'll allow me to make a very short comment on that. It's just specifically in relation to affordable housing contributions on older person developments.
Right.
We're just concerned that the policy may hinder the delivery of such housing simply because there's reference in Part B that proposals must ensure a minimum of 35 affordable housing on gross residential development. And it's something that I raised in our hearing statement in terms of how the standard approach to assessing viability fails to account sort of different viability attributes to older person housing. So effectively, what you find with older person accommodation is that 25 to 35% of the gross internal area is not marketable or valuable effectively because that constitutes things like communal areas, spaces for nurses, other sort of other additional care services. So effectively, each square metre of conventional housing doesn't equate to the same profitability of each square metre of older person housing. So we're just concerned that because HO4 is silent on older person housing, I don't think there's any reference to older person housing anywhere in the policy, whether or not the council may consider allowing some degree of flexibility to the affordable housing threshold when it comes to the provision of older person housing, and whether some reference could be made somewhere in the policy, which, apologies, I think B would be the most appropriate, that would exclude older person housing from that gross residential development. And it would be based on a sort of accommodation room by room basis.
We might, I don't want to duplicate it, but we might come on to that a bit more on under HO6.
That's fine, we can, yeah.
But I think HO6 makes it clear that affordable housing needs to be provided in accordance with this policy.
That's fine, okay.
But the council can respond about the general point about whether there should be a recognition within HO4B that an exception would be potentially applied to older persons' accommodation.
We're happy to wait until HO6 in terms of any comment.
Okay, we'll be on there in a minute. So, okay, any other questions on HO4 then? No, okay. So then I've got HO2, which is dwelling size mix, which is 10.1 to 10.2. So I am relying on the council alerting me to any modifications that you've also proposed on these as we're going through them. Right, so primary concern here is, as we've already discussed it, we've touched on it in terms of the SP03 session, but it's the whether the 25% family homes threshold is correct in terms of this policy, and whether that should be higher in terms of what the evidence base tells us. I think I've got a clear understanding of the council's position in terms of how you've arrived at the 25%. Okay, your response at 10.1.5, to set a target significantly higher than 25% would not accord with the London plan. Specifically, the scheme should generally consist of a range of sizes. Has the council considered a threshold not significantly higher? So when you say to set a target significantly higher, I'm assuming that you're talking around the target to meet with your needs assessment, which is towards the 85%, isn't it? So has the council considered a target higher than 25%? So not significantly higher, but higher.
Ma'am, consideration was given to sort of higher targets, but we still feel that on balance that the 25% is an appropriate balance, as we covered in previous sessions.
So what were those other figures that you discussed, and to what extent did you process those through your evidence base? Well, do you know what the figures are that you've looked at?
And the figures, or the options that we looked at are set out in our Reg 18 sort of local plan in terms of different types of targets that we may set. Still revolving around the 25%, but mainly just in terms of what that 25% may cover.
What, that 25%? Sorry, I missed the last bit of that.
What it may cover in terms of A, not including a target, including a target in excess of the 25%. I will admit that wasn't specific in terms of what that target may be. And then also just whether or not we should exempt minor development from 25%.
Right, okay, so you haven't actually done any exercise in terms of a quantum. The council's view was the evidence base says 80%. We think on our judgment it's 25%, and that's what we're doing. Yeah.
Yes, ma'am. Yep.
Okay. And there was some discussion at the SPO3 session about the delivery of family homes within the opportunity area. And I think the council's view, correct me if I'm wrong, was that it would be likely that that 25% would be exceeded there. Is that right?
Did you say unlikely then?
No, likely. Have I recalled that correctly? Yeah.
And ma'am, we, in terms of opportunity area, certainly that we believe that 25% as a minimum, should be achievable on sites within the opportunity area. But we did also then give some examples in terms of where we have exceeded the 25% on specific sites, such as the Borough Quarter site, for example. So there is scope to exceed that 25%, noting it's a minimum.
So that's on consented schemes. What about the schemes that you're allocating in your plan?
In terms of specific site allocations,
yeah,
and reference to that, we have not identified those particular sites, but there is obviously within the policy itself circumstances where a higher proportion may be achievable.
Within this policy, HO1?
Yeah, so ma'am, that's A12, which again really just looks at how we may settle on a case-by-case basis.
Okay.
The balance, the 75%.
We'll come on to the specifics of the wording of the policy, because I'm not quite sure if it's as set out, whether it does follow a sequential approach. But does anybody have any general comments to raise regarding the 25% threshold? If you could focus it specifically in terms of the wording of HO1.
Thank you, ma'am. Sorry, I've made this point at a few of the sessions previously, so I won't go over what I've said before.
Yeah.
I think what's clear is that from EBHO2, the requirement for family homes is 80%. The policy is 25%. I think the council's mentioned examples. My recollection of that session was the example was 48%. So that is still nearer to 25% than it is to 80% in terms of that family housing delivery on one example scheme. So I don't think there's any evidence before this examination that the council would get close to meeting that 80% family housing needs. And I think in terms of alternatives, I think the essay sets out the council's consideration, and I think we went over this at the essay session, but page 66 of that third paragraph talks about alternative 3, which was meeting in excess of 25% family homes, but it was concluded it wasn't achievable essentially if the council was to meet its minimum housing target set by the London plan. So I think what that says is that the council's focused on the quantitative housing target as opposed to actually meeting the needs and the type of needs within the London Borough of Harrow as identified by its own evidence. So I won't go on too much longer, Mum. You've heard enough from me on this point. I'll leave it there. Thank you.
Thank you.
Thank you. I won't rehash what submissions we've made previously, just to flag that they do follow through to this issue as they did in this SP3 session that we dealt with. I am a little bit concerned, though, that still it doesn't appear that the evidence base from the council in terms of why they've settled on this 25% is anything beyond experience, which I think is the word that was used in the last session, and their own planning judgment. And that is, I think, illuminated by the discussion that we've just had in terms of the extent to which a percentage above 25% has been assessed. There must have been something in the council's mind. It's somewhat troubling that there isn't an ability to elucidate further on what that was. And then in terms of the policy wording itself, Madam, you did ask about that. I did make submissions previously in terms of policy HO1, Part A, 1, Roman numerals 1 and 2. Insofar as a higher proportion of 25% being possible, but the way that the policy is worded, breeding some uncertainty as to the extent to which that would take effect to alleviate concerns in relation to the 25% being so much lower than the 80% that the evidence base suggests is required. But I won't go further than that because I think I've made submissions previously to that end.
Yeah, well, we're going to talk about well, it might be useful for the council to sort of understand your specific concerns about the wording, because then we're going to come on to this issue about a sequential approach and how suitable sites are defined. But
I think that was the main point that I made previously, and it's less of a concern about the wording per se and more that the council relies on it in a suggestion that they would achieve much beyond the 25% such that we don't need to be concerned in relation to the level of need. The reference to suitable sites, in particular at Part A, 1, Roman numeral 1, isn't defined. That is really left to judgment, and there is criteria that's set out at Roman numeral 2 in terms of how the remaining dwelling size mix would be determined on a case-by-case basis. But again, although there is criteria there, it's very much a sort of case-by-case scenario as the wording suggests. So really the overarching point that I'm making is more that there isn't really a great deal of comfort there that we'd be achieving much beyond the 25% to the point that actually we can ignore the evidence base.
okay, so let's just understand with regards to this wording, Mr. Hughes. I don't know if you can help me with this. So you say to achieve this, you set out what the priorities are in terms of dwelling size mix. To achieve this, proposals must apply the following a sequential approach to housing priorities. So the first thing that somebody needs to consider is ensuring a minimum of 25% of all units are family dwellings. and a higher proportion will be required on suitable sites. So sorry, how does that, I'm not following how that's a sequential approach. Well, firstly, is the sequential approach, is it just 1 and 2, or is it 1, 2 and 3? What is the sequential approach as you see it?
The sequential approach would just be Roman numerals 1 and 2.
1 and 2, okay, so that's the end of the sequential approach, okay. So the first thing we need to look at is 25% family-sized dwellings, but then it says, and a high proportion will be required on suitable sites. What do you actually, so where's the sequential approach in terms of that wording?
The sequential approach is essentially that 25% is a minimum, and then if the site is potentially suitable to be able to accommodate a higher percentage, then that is when you start to go through the sequence set out in Roman numerals 2.
So 2 is the criteria that you say are suitable sites, but if it's a sequential approach, then surely you start with your optimum, don't you?
In this case, it's actually the minimum floor, and then we test a level above that as to whether or not it's feasible on case-by-case basis.
Right, so as I understand the steps, as you say the policy wording is, so it's a minimum of 25, that's the first thing, 25% minimum. But then it says, and a higher proportion required on suitable sites. So that's the next, is that the next step of the sequential approach? I don't follow the wording.
Yeah, that's how that policy would operate.
Right, I think that little one needs rewording then, because it's not clear to me how somebody should react. So whether this needs to be 1 and then 2, a higher proportion on suitable sites, and then you need some wording to stay having regard to the following or something like that. So you're linking in part 2. But we know what the evidence base tells us in terms of the local housing need, in terms of the priority for family accommodation. So that is going to tell anybody that it needs to be much higher than the 25%, isn't it?
Yes, it would confirm that the need is greater than 25%, and then that then provides a context as to why 25% is a minimum, and the justification for going above that on suitable sites is that it would deliver that sort of mix in terms of additional family-sized housing.
Right, sorry, little 2, Roman numeral 2, A to F are all factors that the council is saying are going to take into account as whether you determine a high proportion is appropriate, required, as you say, but no, it's actually required. So if you're first having regard to the need evidence, that's going to tell us that it's going to be, it would have to be higher, wouldn't it? It doesn't appear to me to be worded as a sequential approach, the policy wording. Because you're starting off at a baseline which you're going to know is going to be much lower than any of these factors. So you're sort of starting with the lowest common denominator. Does that not make sense?
trying to get my head around where we're heading with this this discussion around the minimum of 25%. I think I'm following your reasoning, but I'm picking up, I think that you're suggesting we disaggregate Roman numerals 1 into 1 and Roman numerals 2, and then what's 2 currently becomes 3, is that?
No, Mr Hughes said that in order to understand whether a high proportion will be required on suitable sites, the criteria for assessing that is part 2.
Yeah.
Yeah.
That's what it is as presently written.
Well, it doesn't, sorry, it doesn't say that. It says will be required on suitable sites, end of, that's the end of little 1, and then we go on to the remaining dwelling size mix will be determined. So this is supposed to be a sequential approach. You've said it's a sequential approach to assessing this.
Yes.
And all that little 1 does is say, you'll be seeking a higher proportion when required on suitable sites.
Yes, it may be that an application comes in at 40%.
Yeah.
And we would look to see whether that site would be suitable for a higher proportion. It's the minimum of 25% is where the starting point is.
Yes.
The opening gambit from an applicant might be, well, I'm delivering 50% here, and I think that's adequate.
Yeah, but somebody reading
because
this...
we know it's 80% is the need, we would then go into a discussion about whether a higher proportion could be delivered on that site.
Yeah, but somebody reading this policy needs to be able to follow. If you're saying it's a sequential approach to housing priorities, they need to be able to follow the steps sequentially to understand, well, I've addressed A, now I go on to B.
Yeah,
so they can, so they can follow the steps.
Where you're going, in the sense that I thought I heard you say that if it came in at a minimum of 25%, and then a higher proportion would be required on suitable sites, and then I thought I heard you say, such as define what those criteria might be to take it into a higher proportion. But that's why I thought you were looking to disaggregate Roman numerals 1. So apologies if I misread you there.
Well, yeah, I'm not going to repeat what I've already said, but Mr Hughes said you then go on to look at number 2, to look at that criteria as to how a suitable site is defined. Well, the policy wording doesn't tell you to do that.
Okay. So are you asking us to look at clarifying that point?
Yeah, well, I think 1, 2. I think I'm going to come back to you on the percentage level.
Yeah.
Because you might need to retest some viability work on that, but I'm going to reflect on that once I've finished the hearing sessions. But in terms of the wording of the policy, somebody needs to be able to read this and understand, right, well, I'm going to propose 25%, that I'm not a home and dry then, because I then need to do these other steps, and I need to understand clearly what these other steps are. And as it reads at the moment, the decision maker has no guidance as to what will be required on suitable sites. Well, what do you mean by that? But Mr Hughes is saying, well, actually, then you go on to the next part of the policy.
That's right.
I think is it just it's a matter of clarifying that the suitability of a site for a higher proportion will be determined.
Yeah.
Is that sort of wording?
So it isn't. So it's not going to. So you're going to be deleting. Will be determined on a case having regard to. So those are the factors that you're going to take account of in terms of whether the site is suitable
for a higher
for a proportion. And then part 2. So that's the end of the sequential steps. Then part 2 just reads as a statement. Should that be for both market and affordable homes should provide? Just says the smallest 2-bed dwellings provide a minimum of 4-bed spaces.
That would make it read sensibly.
Yeah, so should provide. And then development that fails to adequately accord with the delivery of the above requirements. So are you saying that an applicant could say, well, we've got this site, it's heavily restricted by X, Y, and Z, or here's our viability assessment that says we can't deliver 25%. Are you saying then that they don't do the steps at what, A1?
No, I think this third paragraph, just reading it, sorry if this is wrong, but the third paragraph actually needs to be brought into little 2, doesn't it, or however we organise that, because site and design considerations are already considered in
Yeah.
B, and then I suppose we could add viability in there as well if that's not already there, and that would be enough then, wouldn't it? It's only suitable if it meets those criteria, once you've gone through those. So do you need this last one?
Oh, well, I don't know what the council's trying to do there.
I think it's just more wordy than it needs to be. I don't think it's trying to do anything more than that. I think it's suitable. I think you've identified the point, Mum. It's the suitability point needs to be clarified as to when it's suitable and what you consider of that suitability for more than the 20%. You go through these criteria, and we might need to add viability in there as well. And that's it, isn't it? That's where the assessment would be made. I think this 3 is just saying that unless you do go through that sequential approach and try to increase the amount if it ties in with those factors, you haven't complied with A1 or little 2. But this last bit in 3, I'm not sure if it's adding anything. What is it?
I don't think I've got any further comments to make, ma'am. Council has got a clear understanding of where you're going, and I'll go with that.
We've got an action point on that.
Okay.
We'll go back to the wording.
So viability is going to be in the mix then?
Yes.
Just remind me of the policy on space standards. I will come back to you both. What's your policy on space standards for accommodation housing?
Ma'am, it's essentially the space standards set out in the London Plan.
You haven't got a policy on space standards? I think it's probably one of your design policies. Well, when we look at those, we're just going to look back at point 2 as well, because I think that's already duplicating what something is already in.
Yeah, ma'am, I can confirm it's policy GR1.
GR1.
And then big B, little e.
GR1. Yeah. So, question whether 2 is even necessary. Because all you're doing is repeating what the London Plan requirements are.
Sorry, ma'am, just for clarity, so you're referring to paragraph 2 of HO1,
Yeah.
Which basically relates to, the dwelling size. The purpose for that is more in relation to that any 2-bed dwellings that come forward
Yeah.
should be capable of accommodating 4 bed spaces.
Yeah.
So that's a key element of the policy. That's not repeating anything elsewhere.
It says in accordance with the minimum space standards set out in the London Plan.
Yeah, I think the point again is that it doesn't have to be 4 space standards, does it? There are 3 bed spaces as well in the
Yes.
plan. That's the point. So this policy is saying it's got to be with the 4 bed spaces, not with 3, so that it can always accommodate the 4th person.
Oh, I see. Okay, yeah, got that. Okay. Okay. Right. So, any questions on part A, 1, 2, 3? Yeah.
Thanks, Mum. I agree with your suggestion that sequentially the policy is probably the wrong way round, in that you're starting from a position which is much, much lower than the need and then trying to work up to get close to it. And that probably indicates that the policy has been based on a predetermined spatial strategy as opposed to actually addressing need, which is what paragraph 63 of the framework requires to be done. I think as well, when you look at A, B, C, D, E and F under Roman numeral 2, those are relatively subjective matters. So I don't think they provide any comfort that you could get anywhere close to the 80%, or that there would be any strict binding requirements on an applicant in terms of what they need to demonstrate. It is a little bit subjective. Just going back to the evidence, Mum, so EBH02 and figure 54, which is on page 75. So that, again, sets out what the need is. And rather than using percentages, it's probably useful to look at what the figure is. So for 3 and 4 bedroom, or 3 bedroom and 4 plus bedroom dwellings across affordable and market tenures, the total requirement is 12,552. So similar to my point on affordable housing, there's no comfort through this policy and subsequently the planned spatial strategy that figure will be met, and therefore it will be addressing the need.
Madam, same as I've said before, I'm not going to repeat points Mr James has made that clearly I adopt, but just in terms of the extent to which the policy might be reworded and this issue of viability, the Council's barrister made the point that perhaps viability needs to be included in those A to F criteria. I will just flag, though, that the way the policy currently reads to me, at 3, where it says development that fails to adequately accord with the delivery of the above requirements, to me, I read that as all of the above requirements, which would therefore include, at Roman numeral 1, the minimum of 25%. So I'm just flagging that in the sense of, is it that the council is expecting that viability would be a reason out of all of the requirements, including that, or are they, in fact, intending that it's only in relation to the higher proportion? Because it makes a difference.
Yeah, it does, yeah. But I still don't, you don't agree that if you're following a sequential approach, you start with your optimum and then work down? Because, but you don't seem to be, and either you don't, I'd rather you just say I don't agree because of X, rather than, because that to me seems a logical process, because if somebody's coming in with a scheme that's 25%, and you're saying that's what the policy requirement is, you're still saying that they still need to then go on and consider the higher steps.
Well, I don't see a problem with that. I mean, I understand your point about different sequential approaches are, as you're describing, but here, as I've understood it, and again, I'll be corrected, this is aspirational to go beyond the 25%. So 25% is what we have tested and said is the minimum, but there's a hope and an aspiration, and based on evidence of past delivery, that we can go beyond that. So we start with the 25%, and then we look and see, well, actually, can you go beyond it in the specific cases that come before the council? So I don't see any problem with that as an approach to getting more than 25%.
Okay, I think this, I'd look to see what you come up with in terms of the rewording, but it really does need quite significant rewording to enable somebody to understand these steps.
Yeah, I think I fully understand that point, and we will go away with reword that.
Sorry, Madam, it's just one final brief
Yep.
point insofar as the use of the word aspirational from the council. That's quite concerning when the need level is what it is. To say that anything above 25% is being viewed as aspirational, I think makes really clear the way that the council is viewing the need and its ability to address it. And perhaps that gives some, again, illumination insofar as the evidence base and why we don't have something more certain insofar as there having been a specific percentage or specific percentages viability tested above 25%. But I'll say no more on that. I think the point's probably clear.
I'm just respecting the fact that we have the last word on that.
Yep.
I just say that I think is a misunderstanding of the policy approach. The 25% is what the council says is deliverable based on the evidence you've had. It is quite right for there to be aspirational policies that are based on a realistic programme of delivery. There's nothing wrong in this policy taking that approach, and that is also in the NPPF.
Okay. Well, I'll leave that one with you. As I say, I'm having a think about the 25% as a separate issue, but I'll leave that with you in terms of the rewording. So that's just priorities for I think you also probably need to change the heading on this, dwelling size mixed priorities, because that implies that it's for everything. But I don't think you mean that, because then you go on to be specific about flatted developments and housing schemes which are smaller units. So I don't think your heading's quite right on that. So then we go on to look at flats. The highest priority for family accommodation on the lower floors. Relook at the wording. Fail to meet this requirement will be resisted. Can be traced that the scheme would result in a poor quality living environment for families based on the above criteria. What criteria are you then talking about?
Again, it sounds like it just needs rewording to make it clearer. The criteria really is saying that if you can't provide direct access to a private garden, communal amenity space, and all of these other provisions, because you will end up with a poor quality living environment for families, then you don't provide them. But I think that's what we're trying to say.
Okay. You need to
Another one to look at.
need to reword that then. Okay, and then smaller units. That's, you're defining that as studios or one bed, one person units. So does this include or exclude your 2-bed units that provide a minimum of 4-bed spaces?
Yeah, ma'am, that would. Yep.
Would what?
It would include the 2-bed, 4-person units as well, because it's 2 beds.
Okay, so it includes the, well, is that your intention to include those? So I thought you've made the argument that those actually provide a role in terms of family accommodation, an important role.
Yes, but there's a reason that you treat them differently, isn't it?
Yeah, I mean, the purpose of this policy is really just to address quite often where there's schemes where we are literally getting a very limited mix in terms of dwelling sizes in there. So yes, whilst 2-bed, 4 persons in the context of family size housing does play a role, if schemes are still literally just 1 and 2 beds and there's no variety in terms of housing mix as such, that is something which we'd be looking to resist unless there's a clear rationale for why that might be an appropriate sort of mix or proposal. And that's your sort of A to D on that in that paragraph.
So just to be clear, the 2 bedrooms with the 4 spaces would not count in the 25%.
No.
No, I know, yeah.
So remember about that. Just give some headspace, I suppose.
So when you say it would result in over-concentration, how are you defining that? How does somebody reading the policy understand what you mean by an over-concentration? Because I've read the supporting text and I couldn't find, I mean, as a general point, again, it's not, a lot of your supporting text doesn't explain how the policy is applied. It provides sort of general commentary about your evidence base. But I'm making that as a general comment. So how does one understand how you're defining what an over-concentration is?
Would essentially be where there's no other dwelling size mix on that particular site. So it is literally just 1 and 2 beds.
Well, that's not an over-concentration, is it?
Isn't 4.1.9 clarify that in the sense that we're trying to secure inclusive and mixed communities.
Yeah.
So we need to promote more varied size mixes in future housing developments to avoid the oversupply and concentration of smaller housing units. So I think that's what David is, Mr. Hughes is referring to.
Right.
So that becomes an over-concentration when there's not a varied and inclusive mixed community within the scheme.
Okay, but then if you go on to read what H10 of the London Plan says, developments with high proportions of 1 and 2 bed units, generally more appropriate in locations close to town centres.
I don't disagree with that. Is there a contradiction in your mind?
No, I don't think it's... well, I think it's... The London Plan is saying that's a suitable location for 1 and 2 bed units. But in Harrow's view, if you have a scheme that's purely studio, 1 bed and 2 bed units, that's an over-concentration on a single scheme. So I'm thinking of your small sites delivery. A lot of those are going to be smaller units, aren't they, by virtue of the size of the windfall that you're looking at in terms of those?
Yes, I agree.
Yeah.
But I think the policy is suggesting that at ground floor level, there should be some provision of larger units with the gardens and space that they can access for family accommodation.
Well, that's on flats. Okay, I'm going to have a think about the wording of that, because I don't. I'm slightly concerned about how that wording regarding over concentration fits with your small sites delivery. So I'll make a note to look at that. But then the exception to that is older persons accommodation. So no, that doesn't apply to older persons accommodation. Is that what you're saying? Yeah, okay. And similarly, the comment that I've already made on monitoring, I don't need to repeat that. Just check if there's any more questions on 10.2. If anybody has any other questions to raise on dwelling size mix, then now is the time to do that. Right, okay, so is everybody content to try and address accommodation for older persons, HO6? Yeah, okay. So that's 10.3 to 10.4. Just remind me of the page number for the policy. Pardon? 133, thank you. Right. So need, you've addressed that, and then I had specific questions about the requirements of Part 3. And I don't know if Mr. Is it Yearsley? Yes, Leslie, do you want to address your specific point now about affordable housing?
Yes, please, ma'am. Thank you. It was just on, so as I say, so Part 1C of HO6 says that affordable housing is provided in line with policy HO5. But if, as I say, in effect, you know, we're of the view that it's going to harm delivery because ultimately the viability is based on gross residential area. And my point was that doesn't allow for the specific attributes of affordable housing, older person housing, which effectively you've got a position where up to 35% of the total GIA is not a profitable floor space. So it's not the same as conventional market housing, and there should be some degree of flexibility in terms of how that affordable housing policy is applied to older person housing in our view.
Does the council want to respond on that?
Yeah, ma'am. Simply, we don't think that there should be any differentiation between the two different types of housing. There's a need for affordable housing across different types of housing, and therefore it's not appropriate to make a distinction.
Just to add to that, Mark, I mean, this hard issue comes up time and again with regard to older persons housing, and came up in the London Plan examination. Policy H13 of the London Plan, Part B1, states quite clearly the strategic policy is that affordable housing in accordance with policy H4 and H5 on threshold approach. That's the starting point for us, and we compliant and agree with that position.
Okay, I've noted what you've said. That I think the reference, it should be HO4, shouldn't it? Yeah, C, not HO5. Part E, provide the necessary level of supervision will be secured. Should that not be via a legal agreement? Yeah, and then again, I think it's an issue of the reading of the policy. So I think you need something along the lines at the end of 2, maybe something like regard will be had to the following, or something that sets out it doesn't, and you don't have any linkage between 2 and then going straight into A2L. And similarly on part 1D, it has been adequately considered and addressed all design issues in part 2 or part 3. Is that of this policy? Is that, should that be below or?
Yes, ma'am.
Yeah, okay. I was a little concerned with some of the wording on the extra care facilities. Well, it's actually more in the supporting text, but there seemed to be quite a bit of duplication between 1A to H and 2A to L. So part 1A to H is general across the board to C3 and non-C3 older persons accommodation. Yep. And then 2 is specific to extra care. Right. As I read, A just repeats what H already says. H and I, or whether they could be amalgamated.
Yep. So Mum, before we came in, that is a discussion that we had when we looked at this policy
good.
again. It does need to be amalgamated. And
Yeah.
also, I don't think it's appropriate to have the reference to C3 and non-C3 or
Right.
C2. Policies don't tend to have the use classes written there.
No.
So I think we'll have to take those out and just leave the descriptors. And that would have to come out of the text as well.
Right.
And once that's done, then we need to amalgamate those, the requirements or the criteria
Yeah.
in 1 and 2. And that'll make a much more streamlined, legible and effective policy.
Right. And it's things like where you say in J, will address the needs of people with dementia and other long-term health conditions, which surely that should be and or. It shouldn't. You shouldn't be specific about why people might be needing the additional care.
Yes.
And then 3 is in relation to older persons' accommodation as a whole again, or still on extra care?
Yeah, these are the care homes, aren't they? The nursing homes, I think. So it's different, isn't it? Yeah. Care homes.
So what is 3 applying to?
Yeah, 3 is intended to refer to nursing home accommodation.
Nursing home.
Yeah. So it may be clearer if we use the word nursing, but this is the one where they are not active elderly. They are now in a nursing home, basically needing care.
Okay, and that's you're differentiating that between 2 being what?
Yeah. Sorry, Mr. Hughes has just drawn my attention to the glossary where care home is defined.
So you've defined a care home and you've defined an extra care, have you? Oh, hang on, specialist older person accommodation. Not including care homes. So allows people to live independently. So I think just stick the policy wording to what you've defined in the glossary. So specialist older persons accommodation, and then because I think there's quite a significant amount of duplication between these two, and again, you know, part F. If it is a care home, that might not necessarily be just people with dementia. It might be all sorts of other issues. So there's some of these requirements are excessive.
It's quite a lot of reworking required on that policy.
And then once you've done that, just recheck the wording on 4 as to whether part 2 and 3 references are correct. Mr. You've got a question?
Yeah, just a sort of general, I had a couple of general points. I think just back on that, I think I agree that there should be some distinction in there, because some of the requirements for specialist C3 that's not care home are overly onerous, so I agree with that approach. So I've got a point on part A. It is demonstrated that they would meet an identified local need, particularly to enable older people to live independently. It's not clear who the onus in identifying that need is. Is that going to be the onus on the applicant, in which case we don't consider that to be justified? Or is the onus which is already in place from the benchmark in London Plan, which requires 165 units per annum to be delivered, which is not being met in terms of the strategic target? We consider there needs to be a distinction there in terms of who is identifying that need, and if it's on the applicant, we don't consider that to be justified, because we consider that the need is already set in the London Plan by the benchmark that requires 165 units per annum to be delivered.
Dependent, yeah.
Yes, and we discussed this as well before coming in this morning, ma'am. We are not expecting the applicant to justify the need per se for elderly care accommodation.
Right.
What we would expect is for the applicant to identify the particular type of extra care accommodation that they may be seeking to meet. So there are different types of need, and I think that's what we are looking to for the applicant to identify when they make the application. So they may be looking to meet a particular kind of need, but we're not looking for them to justify the overall need for elderly accommodation for older people.
And sorry, and is that specific to care home provision or to all accommodation? To all. Okay.
Well, in A, we will be amalgamating, so it'll be. There's a differentiation between specialist care for older people, extra care, and then there's a different kind of issue for nursing home accommodation.
So don't you need to rework A and B then on that basis, so it's clear to an applicant what you're expecting them to do?
Yes.
Yeah.
It does read as if we're asking them to justify the need for elderly accommodation, full stop.
Yeah.
But I mean, the London Plan says out there is a need. So we're not asking applicants to do that. But my experience has gained when applications have been received, that there is a supporting document which identifies a particular need they're seeking to meet in this application.
Okay, so I think the wording needs to be much more specific on that then.
Okay, fine. Is that okay?
That's great. Thank you very much. Yes, Just another point on 1F. So in terms of sort of just consistency with the London plan, policy H13, I mean generally we agree with the principle of directing such development towards areas that have reasonably good access to public transport, to local services, facilities and other healthcare and infrastructure options. We don't agree with the justification of inserting specific reference to PTAL rated 3 to 6 areas, and that's sort of twofold. The first is because well, one, it's not referenced in the London Plan policy H13, so it's not generally consistent. Two, it's only one measure of accessibility. It's a quantitative measure. There's a qualitative assessment that also needs to be undertaken whereby the actual real-term accessibility of a site is considered, not just the rating, because we all know that PTAL ratings are very black and white. You could be outside the square and you're in PTAL 2, and you're inside the square and you're in a PTAL 4 area. You know, and I think it also then brings a wider point, not to stray into other matters, but brings a wider point then in terms of the friction with the allocation specifically for older person accommodation in the local plan as drafted. So allocations reference 014, 018, which are the only two allocations for older person accommodation, are both within PTAL areas 1B, which is the lowest PTAL rating there is. So in effect, there's a direct conflict between the allocated sites for older person accommodation and that policy as drafted, which means to say that if an application was to come forward, there's an in-principle objection in regards to policy H06 F. So I suppose the first point is that we would like to sort of understand the justification for inserting the PTAL ratings, and just welcome the council's comments, I suppose, in terms of the friction between the draft allocations and the policy as drafted.
Depending on what you're going to say, Mr. Hughes, can I suggest a short circuit that you amend F to say it is in an accessible location appropriate to the needs of the intended occupiers? But if you have a strong view as to why that wouldn't be appropriate, then I'm happy to hear what you say. You do.
No, I was going to ask you to repeat what you just said.
I'm appropriate. Well, then just continue as F is appropriate to the needs of the intended occupiers.
Thank you.
Sorry, Mayor, in terms of that, the reference to PTAL 3 to 6 is really intended to refer to or to cover what is considered to be an accessible location, so that it provides that clarity.
In terms of your own site allocations, you're not doing that for older persons accommodation. They're not in 3 to 6 locations, are they?
They are not, but they then, site allocations then also include measures or planning requirements to address that issue in terms of improving accessibility.
So when we come to look at those site allocations, you're going to say that the criteria is going to be making those sites a PTAL rating of 3 to 6, are you?
Not making it PTAL 3 to 6, but improving, it's a recognition of that issue and then including measures to improve it.
Okay, well that's what I'm going to suggest on F as it stands. When you do revisit this, I just really want to make sure that the council are avoiding a lot of this excessive repetition because it's a very, very extensive policy.
Just to come back on the point of criteria FPTAL 3 to 6.
Yeah.
Whilst we will go through the measures to improve accessibility when we go through particular applications, I'm content with the wording you've offered.
Thank you. Just what you say, 4.6.10, is that consistent with what we've discussed this morning? In terms of the affordable housing policy?
Yeah, I mean, this is why this C3 and C2 reference is not helpful
Right.
throughout the plan. I think we'll have to look at the wording and relate it back to the policy requirements so that it's consistent.
Okay. But is that still the council's intention? A lower contribution if it's 100% low cost rented products? Okay, any further questions then on HO6? No, okay, thank you. In which case then we've got to where we wanted to get to, so that's good. So we'll come back after the lunch break and continue with GR10. And then the remainder of the policies, I might just have some general comments on the ones that I haven't listed. But they're not going to be to the level of detail that we've gone into in terms of these ones. So we will break then until 2 o'clock. So the hearings are adjourned until 2 o'clock. Thank you. Okay, it's 2 o'clock, so the hearing's resumed. So we're going to continue with this session and now look at policy GR10, which is the MIQ responses 10.9 to 10.11. So part F of the policy, you've said it's twofold. It's to do with being accessible to all and also suitable access and safety of access, is that right? I'm just wondering on that basis whether that covers everything that you think it intends to cover, or whether it would be preferable amalgamated with E. So something along the lines of safe and suitable access is provided along with appropriate levels of parking. Yep.
That would be more effective, I think. Yes.
Yeah.
I mean, I should maybe just say at the outset that this is another policy that we looked at quite a lot before the session today.
Oh, good. Okay.
And we think, and if anyone disagrees, they will say, we think that quite a few of these. So we have a general bit at the top, and then the next sections deal with the specific elements of the heading there. So you have infill and so on. there's quite a lot of repetition
Yep.
or loose language in all of those extra bits. So we thought that this is another policy, without changing the essence of it, could be streamlined.
Good, okay. I was going to make that same suggestion, so that's really helpful.
Thank you. So that's fine then. We've got that down as a
Okay.
point.
So you're going to revisit it in terms of the repetition?
Yes, and also things like, for example, I mean, it's not everything, but G addresses any relevant supplementary
Yeah.
guidance. Not sure that that's really needed.
No.
Satisfactory access to the development comes in CB again. So,
Yeah.
you know, these sort of things we would just pick up, I think.
Okay. That's good. And also, just when you do that, I don't know whether you will pick this up or not, but on garden land,
Yes.
so E,
Yes.
you either have to, you demonstrate compliance with the above, and then it says it won't be supported.
Yeah, on individual, yes, we'll pick
Yeah.
this point up. But there's a number of points on this. One is the heading. If you look at GR10,
Yep,
there it describes back gardens. It calls them back gardens.
yep,
Then we have garden land,
Yeah.
and then we have rear gardens. So I
Yeah.
think we need to be clear what we're talking about.
yep.
Then there's the question about, is it that rear gardens are being resisted only if it's individual rear gardens, or are they being resisted if then generally, or will they be supported if it's part of a comprehensive development of a number of plots? And then what's a number of plots?
Yeah.
So we'll rationalise all this.
Good. Okay. Okay, well, that all makes sense. So that's GR10 then. Then on to HO12, which is the Gypsy and Traveller provision, which is 11.1 to 11.9.
Yes. 11.1 to 11.9. HO12, isn't it? Yep. That's 167.
Thank you.
Yeah.
So it's 11 point what? So the reason you say at 12 additional pitches provisional is just remind me why that is. Is that because you're saying that? Well, that's why are you saying provisional?
It's provisional because it's based on the forthcoming GLA, Gypsy and Traveller Needs Assessment, that's yet to be finalised.
Sorry, I'm just going to pick up my notes on this one. So when you say 11.1.3, open to the inclusion of modification to clarify regarding the needs, I think that, yeah, that should be included. And similarly, there appeared to me to be quite a bit of repetition between the criteria on 3A to G. So I would suggest that A and B can be amalgamated, and there is an element of repetition on between F and G.
Maybe E and C as well, I think. Perhaps.
B and C, yeah. Just the wording on a site that's on D, well integrated into the locality.
Site location well integrated into the locality.
I've re-looked at the wording on the PPTS on that, and I don't understand where you're coming from on that. But I'm just wondering whether well integrated is the correct word for that.
No, I can't remember what the PPTS says. It says something similar, doesn't it? It says, yeah. This happened. Right, existing level. Is the point you were looking at promote peaceful and integrated coexistence? Is that the point?
There was some specific wording in there regarding if you're developing policies.
Yeah. Let's go back. Yes, plan making. I've got that.
For planning policies, this means, and then
yes.
hang on, I'll put it up as well.
Yeah, I think it's that 13, is it? Paragraph
13, yeah.
So it's ensure their policies. This is the bit I think it is promote peaceful and integrated coexistence between the site and the local community. Is that what you're getting at here? Or reflect the extent to which traditional lifestyles.
No, it's more the point that a number of these gypsy and traveller sites, as they come forward, may not, in terms of meeting the needs of that community, they may not want to be well integrated with the local, into the locality.
Yes.
So it's the wording of
it's not good wording, actually. Yes.
Sorry?
It's not good wording
No.
for that.
So I understand in terms of access, so maybe access to education, health and public transport, but it isn't an issue with being well integrated.
No, it's not. It's not.
So maybe it's just a simple change, a location that has access to.
Yeah.
Because it's really around providing suitable access for children to get to school, I think.
It's sustainability in a wider sense, isn't it? Yes.
Okay. And then so F is, 5 as is. So Watling Farm is a council-owned site with 2 existing pitches on it, and it's an existing allocation in the adopted plan. Yeah. And you've undertaken your own assessment there of the existing capacity available, which you've gone through at 11.2.4 to 11.2.5. And then you've cross-referenced to what's happening at Enfield in terms of the estimation of additional capacity there. Is that right?
What has Enfield got to do with it? Where's the reference to Enfield?
In the footnote to
Oh, I
11.2.6.
see, yes. Footnote 11.2.6. Based on approaches.
So I need to understand whether you've got sufficient evidence to justify that site has the capacity for those additional pitches that you're identifying there.
Yes. Well, I'll leave it to officers to answer, but I know that they have done this assessment, and it had a permission for 15 pitches, which haven't been built out. Only the 2 were built out. So on that basis, it certainly has enough for a 12. But I think, is there anything you want to add, officers?
Okay, so when was that permission granted?
That was granted, well, I don't, do you remember when it was granted?
1974.
In the 70s, at some point.
For 15 pitches,
For 15 pitches, yes,
of which only 2 are built out.
yes.
So just talk me through how you've the steps that you say that you've summarised at 11.2.5 and 11.2.6.
Yeah. I think Mr. Hughes is going to do that.
Yes, ma'am. So essentially, first thing we looked at, first step, was to look at government guidance. So you make reference to the 2008 guidance there. The observation that guidance makes is that there's no one-size-fits-all in terms of measurement of a standard pitch or site. And then sort of identifies the sorts of things that should be accommodated for in terms of the types of amenities and those sort of aspects.
Yeah.
But in the absence of any sort of specific references to or guidance from government in terms of what a pitch size should be, we had regard to sort of other London boroughs in a similar situation in terms of the North London sort of locality, how they're sort of approaching it. That sort of gave us the indication of a capacity of 18 pitches.
Mm-hmm.
And then that was sort of then related back to the sort of 15 pitch capacity that had been sort of previously granted permission as sort of a cross-check.
And when you say 11.4.3, the council intends to commence work in partnership with the local Gypsy and Traveller community. What does that entail, and when's that starting?
That is very much just in recognition of the fact that the forthcoming GLA study identifies the need, and then so it would then be working through in terms of how that need would then translate into actual delivery on the site, allocated site, proposed site.
So you're saying that won't start until the GLA work is completed, or?
Yes, that's correct.
So we've talked about the criteria as at 11.5, and then there are specific concerns from Historic England. And that's specific to the site allocation, so we'll look at that as a separate matter. We'll just make a note to come back to that in terms of GB2. And then this reoccurring issue about greenbelt boundaries, you're saying you're not altering the boundaries. It's an existing gypsy and traveller allocation. Okay, we're coming to the specifics of that allocation at a separate session, but I think that's everything in terms of the wording itself. Sorry, I'm just revisiting the wording of 4.12.6. I'm not quite sure that characteristics of expected of Main Street housing is correct.
Those first 4 lines.
Yeah.
Not right.
No, okay. So I think just revisit that one once you've reworked the revisited the criteria to ensure it just aligns with what your the supporting text should be adding something to somebody understanding the policy in terms of okay, what do the council mean by that? And I think on a number of these, I'm not quite sure that the policy is the supporting text is achieving that. And then similarly, whether you want to, I'll leave that one with you, 4.12.4, there's a quite a significant text there about the Reg 18 process, whether you want to revisit that. Is that going to be relevant to an adopted plan? Well, I would suggest that's an additional mod. And 4.12.5. So just a few other bits to revisit there, but I think that's it in terms of the policy itself. Let me just remind myself on the MIQs. Yeah, that's all. Okay, and then so we're then on to other housing policies. So if we just start with these HO2, we'll just start there, but I don't think I've got any comments on that one. Yes, 108, yeah. Yeah, so no questions on that one. Yeah, this is on HO3, optimising the use of small housing sites. This is page 113. The map to explain 800 metres from town centres and stations and a PTAL of 3 to 6. That's the one that's at page 115, is it? does that include sites within the part C of that? So it says areas 800 metres from town centre and stations. Does that cover all of those criteria? Or is it just,
Yes, it does.
yes, it does, okay.
Yep.
I mean, is it, if it's, sorry, you can have to refer me to another part of the evidence and space, but if something isn't on a PTAL 3 or above, surely it's within, is it not within 800 metres of the tube or rail station? No. What's the distance then? At 3?
Sorry, ma'am, can you just repeat that?
What's the distance? Where are you setting out what your distances are for a PTAL 3?
PTAL 3 to 6B are essentially the coloured versions, not the beige sort of colour.
Yeah, so sorry, what's the distance?
There's no distance in relation to PTAL, it's literally what the PTAL level is for that particular part of the borough in terms of the site. So it's the criteria relates to
Right, but sorry, to achieve that rating, isn't it going to be within 800? I just wonder if all those three are just doing the same thing, A, B and C.
Yeah, but those criteria are essentially taken from the London plan in terms of what constitutes the small sites policy.
Oh, okay.
Admittedly, there will obviously, as you say, be double up in terms of you next to a tube station. You would generally be in a 3 to 6 PTAL level.
Right, sorry, just remind me of the London plan policy then.
It is page H2
H2.
at 166.
Thank you. Right, H2, small sites.
So maybe in terms of the actual PTAL levels and distances, that's set out in paragraph 4.2.4 of the London Plan supporting policy H2. So that then relates to the incremental intensification of existing residential areas within PTALs 3 to 6 or within 800 metre distance of a station or a town centre boundary.
Yeah. But you're reading that goes as far to say that if it's not within those areas, it shouldn't be supported? That's just outlining where they anticipate that most of the supply is going to come from, isn't it?
And part 3 of our policy HO3 then addresses small site development outside those locations, and then sets out some more of a criteria based in terms of where criteria based approach to those such sites.
Right, I don't want to revisit the small sites evidence, but is that, in terms of your deliveries, is that generally within these zones, or is some of it falling? Because you are very reliant on that as a source of supply. So in terms of the past delivery, is that falling within these categories? It just seems quite restrictive. It's an important part of your supply, and I'm trying to understand why wouldn't you just have a policy that just says small housing development will be supported, provided that, or words to that effect? Because your supporting text says proposals outside of these locations are less likely to be considered as sustainable and have more potential to cause harm within such locations. Well, that's quite a big leap in assumptions. Why do you want to, why the focus on those areas?
It's really just driven by paragraph 4.2.4 of the London Plan, which really just sort of identifies those areas in particular in terms of small site development. Paragraph 3 of the Harrow policy, again, sort of doesn't preclude small site development outside those areas. It just sort of identifies.
Right, but if we're going to be specific about the wording, so the council is saying you're going to be supportive of proposals where they meet, where they're on those sites A, B, or C, and then on the if it's not in those criteria of 1, A, B, or C, you're then applying a whole new set of criteria. So why is the question? All that the London Plan says is that's going to be the main source of supply. It doesn't say, and policies should be drafted to focus on those areas. You're reliant on this in terms of quite a significant, there aren't any allocations for this.
So this really applies to everything, those within one and those outside those locations. Seems to apply to everything.
Right, okay.
See, I just see if you look in the brackets.
Including those outside of locations.
Part 1. It seems to cover everything. Two shalls. another thought here, that paragraph 1 in and of itself could go. It's not necessarily required. The wording could be more positive in relation to just small sites.
So
generally.
start with 3.
Yeah, start with
Yeah.
3, maybe just change the wording a little bit.
Yeah.
Yeah, ma'am, that's on the basis that paragraph 1 is essentially a repeat of the London plan policy.
Yeah,
isn't it,
exactly.
Where
Okay.
most of the most small sites are likely to come through.
Yeah, and since we're not excluding
We're not
anything,
excluding
so
them.
just what's the point of it?
Yeah. In paragraph 3 then sets out the criteria.
Yeah, okay, so you'll amend that wording to introduce those criteria.
Yeah.
It would have to be.
And then part 2, what's the relevance of referring to that, and what in additional does that cover that part 3A doesn't?
I don't think it does.
No.
I don't think it does.
Okay.
I think it's,
I mean, these are small sites, aren't they?
Yeah.
They're not going to be,
Yeah.
okay. So you sort that out.
Yeah.
so that just becomes the first.
I would question whether E is necessary, because that's just cross-referencing to an existing policy. Could you amend 4 to be positively prepared? And 5 is the monitoring thing again.
Subject to your thoughts, I'd like to leave the map in, because it's just helpful to define how the London plan definition
Yeah,
applies
which
to
is
our
what you do at 4.3.2, so yeah.
Yeah.
Okay, and then HO4 we've addressed. HO5, housing estate renewal and regeneration. We haven't looked at this, have we, this morning? No. I think it's just a typo on AE, where it says any further uplift should, in genuinely affordable housing, provision should be made. Should it be? I'm not quite sure what word it should be, but any further uplift is not correct. Pardon? Sorry, I can't hear you. And up. And so delete further. And uplift, okay. Then at HD, reference to plain informal recreation space. When you say local plan policies, do you know which one you're referring to there? CI2. Yeah, okay, so I think that would probably be preferable. CI2. Could you just revisit the wording at K in terms of exceptional local circumstances, or have you set out in the supporting text what you mean by that?
Sorry, ma'am, just in relation to that, that is one of the main modifications, sorry, on page 12 of the modifications.
Page 12.
Yeah. So essentially it deletes after, or deletes unless exceptional local circumstances are
Oh, yeah,
demonstrated.
great, okay, right, thank you. I just wondered whether 5 was necessary for effectiveness, or if that's just repeating what is already evident within the policy. Because you already talk about in 3 about wider master plan approach. Yeah. And then I would ask you to consider whether 4.52 to 4.54 are necessary, because they don't add anything in terms of explaining how the policy is going to work. And then 4.5.13 appears to introduce the reference to exceptional cases, whereas actually that's quite a bit stronger than the policy wording itself in terms of open space. So you just look at that. And then older people we've dealt with. H07 I didn't have any comments on. Or H08. I think I asked a couple of questions on that in the MIQs. No, but I don't have any questions on the student accommodation policy. And then H09 we have dealt with. H010 I don't have any additional comments on. Or H011. And H012 we've already addressed. So I think that's everything in terms of other housing policies then, unless you've got anything else you would like to raise. There's no other modifications that you need to talk about today, or? No, okay. Okay, well, you don't have anything you'd like to raise, Mr. Kazi? No. No.
25% allocation for me, and I think I
in terms of the family homes. Yeah.
Who are you benefiting? Surely the local plan is to benefit Londoners and local residents. And to me, 25% is completely inadequate.
Okay, noted. I've got a note of that. Thank you very much. Okay, so that includes the discussion for today then, and then tomorrow we are back onto the site allocations session with the opportunity, Harrow and Wheelstone opportunity area and sites OA1 to OA10 in the morning, and then the afternoon OA11 to OA17, and the 2 Greenbelt sites as well. So do you want to, is it worth going through actions from today or modifications from today?
We can do. I mean, there's 2 ways. There are obviously policies that we have said that we will take action on in terms of the modifications. Then there are the detailed points on each of those policies.
Yeah.
So up to you what's more helpful, just to...
Well, I think it might be just useful just to run through the chapter, and just so we're totally clear as to which ones you have made a note on. So if we just start at the
H09 is where we started.
okay, yeah. So if you just give me the page number then.
Right. Sorry? No actions, no. It's all main mods.
Yeah, so I'm going to have it. For actions for me is to come back to you on the family homes percentage. I'm going to have a think about that.
Yes. Yes. Yeah, that's right.
So H09.
So H09, there are a number of modifications that we're going to be looking at, but just in broadly, it's B and I to see if they're repeated in the plan.
B and I.
Yes. Is it I or L? Yeah, I. So it's, yes, it's big B, and I'm assuming little I above.
So I is part of G.
I is part of G, that's what it looks like.
Right.
Servicing and... yeah. Then it's same policy, suggest E, I to, well, little 1 to 3, and then 1 to 3 is deleted. Then it's paragraph 4.9.10 to add this into the policy as opposed to the supporting text.
Yeah, I think that is actually already covered. That was my error. I think that's already addressed as part of J.
Okay. Part F to be changed to be more positively worded, specifically will not be supported. That's what I have on 09, and then it's 04.
Yeah, and I'm going to have a think about the evidence you've presented on AD. And then which one's the next one, sorry? H04.
H04.
Could you just give me the page number?
Yeah, it's page 118.
Yep.
And here we have part A, change the reference of E to M. That's just an error, I think.
Yep.
Then part N and O to be deleted.
N and O, yes.
Part D, reference to policy H5 of the London Plan instead of what's there, I think. And wording of development proposals will carry greater benefit to look at that as appropriate wording or not. That's in D. Then parts H and D, to look at meaningful discussion.
Yes.
Yeah. That's all I have on HO4. Then it's HO1.
Right, I think you're going to revisit the wording to B in relation to Mr. Burrent's representation.
In B.
Yeah, so the reference to initial minimum and the reference to as well as demonstrating all options have been explored to achieve the borough-wide target.
Right, yes.
Yeah.
Okay, you know that one. That's B,
Yeah, so that's HO4.
Then it's HO1. HO1 takes us to page, that's page 103.
Yeah.
And then for this, so one little I or little one needs rewording. This whole part needed to be reworded to deal with the sequence and the meaning and to clarifying what is being said here.
Yeah.
So really it's to do with the suitability requirement, to look at that.
Yeah.
Then part 3. What about part 3? Yes, part 3, whether or not that's necessary or not.
Yeah.
Then looking at changing the title.
Yes.
Again, part A3, the wording should be looked at against about positively wording.
Yes.
Then part B, look at flattered development, to look at the wording of that. Part C, part 5 is the concern over this over-concentration point. Then part D is we don't need to repeat these monitoring comments.
That's a general comment.
General comment, that's yes, it's similar to yesterday's discussions.
Yeah.
Then I'm on HO6. And that's page 133. So this we're going to be amalgamating quite a bit of this.
Yeah.
Removing these references to C3 and non-C3 and make sure that that's all rationalised throughout the policy and the text. Quite a lot of repetition there. We're going to stick to the wording that's used in the glossary, so there's not going to be these different definitions. Part F might not just relate to dementia, but other illnesses as well. And then to recheck the wording after amending that on part 4 to ensure part 2 and 3 references are correct.
Yeah.
Part 1F to just refer to in an accessible location for the intended occupiers rather than all of this wording here. Then that's actually all. That's all I've got on HO6.
So I think 1C is policy HO4, not 5.
1C is yes. That's right. Yes.
Okay.
And then that's the morning session.
Yeah, and then sorry, I think you're going to cross-check the where you've referenced, and I know you've already picked up where you've referenced dementia throughout.
Yes.
Yeah.
Yes.
Okay.
I mean, overall rationalising all that.
Yeah.
Right. The afternoon session we started on GR10, sorry, and that's on page. That is page 74.
Yeah.
Now this is another policy that we said right at the outset we would revisit this entire policy so that it's condensed and more coherent, avoid repetition, rationalise the references, particularly back gardens and number of plots and so on.
Yeah.
So that entire policy will be revisited.
Yeah.
Then it's HO 12. And that is on page 167. So this is gypsy policy.
Yeah. Okay.
And this one has got now the need to modify the needs of part 1. No, it's not part 1, is it? Modificate. Yes, paragraph 1. Yes. What are we doing to that? Clarify the needs at part 1. Was that just to remove this provisional or?
No,
Okay,
to address future travelling needs.
future travelling needs. Oh, yes, to add the words. Yes, sorry, that's right. To clarify the needs, what is this a reference to updated evidence? Is that the bit? Yes, yeah, to add the words to updated evidence. That's a suggestion that's been made in the response, I think.
Yeah. Sorry, just whilst we're on this, can you just clarify why you said up to 12 pitches? Would that?
Up to 12 additional pitches.
Yeah.
Yeah.
Should that be up to 12? Should it? At least.
There's 2 on site already,
Yeah.
so this would be a 12 additional, taking it up to 14.
Yeah.
I suppose it's the point that there's a reference to 18 somewhere, isn't there?
Yeah.
You know, so the one is a permission for 50, isn't it?
Yeah. Is 12 to do with the need? Is it up to the first 10 years? Is that why? David? Sorry? I don't. Yes.
Yeah.
At least 12. So it
Yeah.
should be at least 12
Yeah.
additional pitches. Yeah. Thank you.
Or to be consistent with how you've referenced other housing, a minimum of.
A minimum of
Yeah.
12, yes. So that's HO 12 first point. Then HO 12 paragraph 3, so part 3.
Yeah.
A to G, there's repetition there.
Yeah.
And we looked at that, A and B to be amalgamated, repetition between F and G, B and C.
Yeah.
Remove the wording in D about well integrated into locality.
Yeah.
That's not appropriate.
So you're going to check the
wording.
PPTS
Yeah.
definitions there.
They're not appropriate. And just simplify it to say it has access to, that sort of wording.
Yeah.
Then it's a text at 4.12.6.
Yes.
Again, those 4 lines need
Yes.
to really go. They're not appropriate. Yes, those go. And go back to this provision once the criteria has been amended to make sure it aligns.
Yeah.
And the supporting text should be added to the policy for people who don't understand policy. What was this bit? Supporting text should be added to the policy for people who don't understand.
Sorry, that was just a clarification of any disappointments in my own mind.
Okay, so that we got that.
I think it was 4.12.4 and 4.12.5, this reference to the Reg 18 plan.
Yes, check the reference to be revisited, and also 4.12.5.
Yeah, but those, keep those on your additional mods there. I don't
Additional
want to see
mods,
those.
yeah. And then we were moving on to HO3,
Yeah.
and that's on page,
Two shells.
sorry?
2 shells.
2 shells, yes, HO3. 113, that page is.
Yeah. So this is your optimising your small sites.
Yes, so this is now, so yes, HO3. So again, repetition of shall. Part 1 we've said can be removed and the wording more positive.
Yeah.
Question whether part 3E is necessary. Part 4 to be positively worded. Part 5 is the monitoring issue. And paragraph 3 would become 1 and become
Yeah.
the introduction paragraph. Then it's HO5. So this is housing estate renewal, page 126.
Yep.
So this is to, there's a typo at part 1AE, delete further and change any to an. So this was to do with the affordable housing. Then part H is D, remove S4 and add CI2.
Sorry, I think the land and plan policy reference is correct. It's the bit local
Yes, I
plan
can see that,
policies.
yes. So that stays, it's just to change.
So it's
land
just
and-
local plan policy CI2.
Yeah. See, I just add that instead of policies. Then 5 is repeated at 3, so we can remove that.
Yeah.
Supporting text, revisit 4.5.2 to 5, whether these are necessary.
Yeah.
And supporting text 4.5.13, revisit to check if necessary.
Yeah. And I think K, you've already drafted a main
already-
modification.
yeah.
Yeah.
So those are the mods for today. But there's no action points as such other than this.
Okay. Okay, thank you very much. Yeah. Okay, so yeah, tomorrow we'll be on the site allocations sessions.
Yeah.
Okay, so we'll start back at 10 o'clock then?
Yes.
Yeah, perfect. Okay. Thank you all for your contributions today then. The hearing's adjourned. Thank you.
Thank you.